Welcome to participants from around the Pacific and other parts of the world to this fourth webinar in a series of regional launches for the Oxford Commentary on the 1970 UNESCO and 1995 UNIDROIT Conventions, published by Oxford University Press last year. Regional webinar launches have also been held in Asia, Europe, and North America earlier this year, and are also being planned for Latin America, Africa, and the Middle East and North Africa in coming months. This Oceania regional launch is organised under the auspices of the UNESCO Chair in International Law and Cultural Heritage at the University of Technology, Sydney. We are fortunate to live and work on the unceded lands of the Gadigal people of the Eora Nation, who have been led by elders over millennia, who have cared for country and culture. These regional webinars coincide with the 55th anniversary of the adoption of the 1970 UNESCO Convention and the 30th anniversary of the adoption of the UNIDROIT Convention concerning the regulation of the trade in cultural objects and facilitating restitution claims, and the World Conference on Cultural Policies, Multilateral, which was held in Barcelona recently, which emphasises the issue of illicit traffic and restitution as one of the major themes in the promotion of culture as a standalone sustainable development goal. Experience teaches us that the concerns around regulation of the art antiquities markets and multilateral efforts to address it have been particularly acute in our region because of the cultural losses sustained during colonisation and those that continue to be suffered because of illicit trafficking. This regional webinar, which focuses on Oceania, is therefore important for many reasons for its peoples and their cultures. This event and the broader conversation we will be having is inspired by the publication of the Oxford Commentary, which was co-edited by me and my dear colleagues, Drs. Andrzej Jakubowski and Alessandro Cecchi. Our panellists this evening all made important contributions to this volume. I am deeply grateful to them for giving of their time, knowledge and expertise for that publication and for joining us in this discussion today. Before I introduce our first panellist, a bit of housekeeping. The panellists will be presenting for about 10 minutes, and this will enable a period of Q&A at the end of the final panellist's presentation. Attendees are asked to pop their questions that they may have for the panellists in the Q&A function. These will be put to the panellists at the end of the last presentation. The recording of this webinar and information about the publication will be made available on the UNESCO Chair website, links to which will be provided to participants after the event. Now let me begin by introducing our first presenter, Professor Craig Forrest. Professor Forrest is a Professor of Law and the Director of Marine and Shipping Law Unit at the University of Queensland Law School. He has a long association with UNESCO. He has acted as an independent advisor to UNESCO regional meetings in the Asia Pacific and Caribbean. With the UNESCO Secretariat, he has prepared the model law for the implementation of the Underwater Cultural Heritage Convention for the Caribbean islands, consulted on the protection of underwater cultural heritage for the states of Micronesia, and undertaken national interest analysis and gap studies on underwater cultural heritage in the Solomon Islands, Marshall Islands, and Fiji. He is the Australian representative on the International Law Association's Committee for the Safeguarding of Cultural Heritage in Armed Conflict and a member of ICOMOS's International Committee on Underwater Cultural Heritage and also an Oceania correspondent for UNIDROIT. Professor Forrest has written numerous leading publications in the field of cultural heritage law, including his International Law and the Protection of Cultural Heritage, published by Routledge in 2010. It is a reflection of the esteem with which his work is held that he has had visiting teaching and research positions at leading universities in the United Kingdom, Canada, and Asia. Professor Forrest has long manifested a dedication to the promotion of culture in international law, particularly as it relates to movable heritage. Welcome, Professor Forrest. The floor is yours.
Well, thank you, Anna, for those very kind words, and thank you for the opportunity to participate in this webinar. But more especially, thank you for the opportunity to contribute to what is going to be, no doubt, the leading work on these two conventions. It is comprehensive, it is thoroughly researched, it has all the leading authors in that work, and my very modest contribution was warmly welcomed when I was invited to do so. So my contribution to that work concerned the temporal scope of the UNIDROIT Convention, especially in terms of its non-retroactive nature. But to understand that retroactive nature, or the non-retroactive nature of the UNIDROIT Convention, you really need to understand the history of the 1970 Convention and its temporal scope as well. And because of that, I guess my intervention lends itself to an introduction to these two conventions. So turning to the first of these two conventions, the 1970 Convention, of course, at the heart of this convention is what we might loosely describe source states, and I use that term advisedly, to try and retain and protect cultural heritage from illicit export. And equally loosely, the desire to have market states implement legislation that would make it illegal to import cultural heritage that had been illegally exported from those source states. Now, the impetus for this convention really came from states like Mexico and Peru, who long had difficulties enforcing their legislation, which made it illegal to export cultural heritage, because most of that heritage ended up in market states where, because of the reluctance to enforce the public laws of other countries, market states would not necessarily make those imports illegal. And so, as you can see in the convention, in Articles 3 and Article 6, there's a mechanism for source states, if you will, to make it illegal to export certain categories of cultural heritage, and importantly then, for the market states to make it illegal to import that into their territory. Now, at the time that Mexico and Peru were advocating, amongst others, were advocating for this convention, this was the late 1960s, at a time of decolonization. And so you had the emergence of newly independent states, particularly in UNESCO, with the power to have a mass voting bloc in UNESCO, looking not just at illegal exported cultural heritage at the time, but also the heritage that had been lost during the period of colonization. That includes that heritage had been lost when the laws that applied to that export was the colonizers' laws, but also then laws that had been implemented to protect that heritage, but where that heritage had left that source state prior to this convention being adopted. So at the time of these negotiations, some of these states, particularly those newly independent states, were eager to try and include within the convention an obligation to address the illicit export of this heritage that had occurred prior to 1970. That unfortunately failed, and it failed because there is in international law a well-accepted principle reflected in the Vienna Convention on the Law of Treaties that treaties should not apply retroactively. That was hotly debated, but nevertheless failed, and certainly market states were very reluctant to implement anything that would make what was legal illegal retrospectively. Of course, the convention tried to deal with these issues, and it did so in Article 15, which tries to recognize those other processes that deal with categories of cultural heritage that are not covered by the temporal scope of the 1970 Convention. Also important was the establishment of the Intergovernmental Committee for promoting the return of cultural property to its countries of origin or its restitution in cases of illicit appropriation. Again, an attempt to deal with a category of cultural heritage that was temporarily excluded from the scope of the 1970 Convention. The 1970 Convention is now more than 50 years old. It has 149 states parties, and over the time of that 50 years, that state party membership has grown over time. So some of those states are only recently joining this particular convention. It is, however, over 50 years old, and it is a product of its time. The drafting reflects the concerns as they existed in 1970. It is somewhat dated. It is subject to different interpretations, and it's certainly subject to different mechanisms of implementation that reflect those different interpretations. So the 1970 Convention reflects a diversity of views on this subject matter. That said, it is still, after 50 years, the most important convention on the attempt to restrict the illicit trafficking of cultural heritage. That said, in our region, Oceania, which is, of course, is what this webinar addresses, there are unfortunately only 2 states that are party to the 1970 Convention. There are approximately 18 states within that region, depends on how we interpret Oceania, but of those 18 states, it's only Australia and New Zealand that are party. And I'll return to that in a moment. Turning to the UNIDROIT Convention, of course, the UNIDROIT Convention, adopted, as Anna said, in 1995, addresses a number of issues that the 1970 Convention was not able to address, and those really are those private law issues such as ownership, compensation, and time limitations. And the convention was designed to complement the 1970 Convention, which is why so often we talk about these conventions almost as two sides of the same coin. Now, during negotiations for this convention, many of the states that were concerned with the temporal scope of the 1970 Convention raised those issues once again. And those issues were, what of that cultural heritage that had left prior to 1970, or in this case, prior to 1995? So that issue, again, was hotly debated within that convention, and it led to a number of mechanisms to address those concerns. And one of the concerns was that these conventions, although excluding some of that heritage, ought not to be interpreted in a mechanism in a way that would legitimize any of those previous concerns. And so the clause that I had the privilege to address in this commentary was Article 10. It's headed rather innocuously transitional clauses, but it nevertheless sets out the temporal scope of this convention. And the temporal scope of that convention really is that in the chapter that addresses theft of cultural heritage, and the chapter that addresses the illegal export of the cultural heritage, the convention essentially, and I'll simplify this, but essentially only applies when the relevant states were party to this convention. So for theft or illegal export, the exporting state must have been party to the convention, and for the receiving state or the state in which the theft, the stolen object is found, must also be a party to the convention at that time. Now, the temporal scope of those conventions therefore exclude a significant body of cultural heritage. But at the same time, it covers anything that occurred after 1970, or at least in respect to the UNIDROIT Convention after 1995. And it is there to address this ongoing concern about the illicit trafficking of cultural heritage. The UNIDROIT Convention is perhaps not as successful as the convention deserves. It has 56 state parties, and in Oceania, there's only one state party, and that is New Zealand. Australia is not yet a state party. Now, the temporal scope of both these conventions provides then this minimum level of protection for the illicit export of cultural heritage, and for the second convention, stolen cultural heritage. But in their implementing legislation, states are bound by this minimum, but they may include provisions that extend this beyond that minimum set of protective measures. And in Australia, as a member of the 1970 Convention, we have a reflection of that in our own legislation, which in some ways addresses the retroactive nature of these conventions. So Australia's implementing legislation of 1970, it has a provision in section 14, which provides that where a protected object of a foreign country has been exported from that country, the export was prohibited by a law of that country relating to cultural property, and the object is imported, the object is liable to forfeiture. This provides a degree of retroactivity in that the illegal export from a foreign state does not need to take place after the convention has come into force for Australia, which is 1986, so it could predate 1986. Indeed, it does not need to have taken place before the convention came into force in 1972. It can predate that. So it has a degree of retroactivity in it, even though the 1970 convention doesn't necessarily deal with that. And that is because there is, in that implementing legislation, scope to extend that beyond that minimum level of protection. Moreover, the Australian legislation does not require conventional reciprocity. In other words, that other state who has lost their cultural heritage does not need to be a party to that convention. Now, that's really particularly important in our region because, as I said earlier on, the only states that are party to the 1970 Convention are New Zealand and Australia. None of our island nation neighbours are a party to this convention. Not being a party to that convention, however, doesn't prevent Australia, for example, returning cultural heritage that's been illegally exported from those countries. So that retroactive nature of the 1970 and 1995 conventions and the scope of those conventions are subject to some extent to national implementation. Although those measures may may help, for example, our island neighbors, I don't think that's an excuse for non-ratification. So the question then arises, why are our island neighbors, those states, approximately 18 of them in Micronesia and Polynesia, why are they not party to these conventions? Well, on a positive note, the lack of ratification may reflect the fact that there is no need for these conventions. Perhaps it is the case that there is no illicit trade in Oceania. I don't think that's likely. Even if the scale is not great, the loss of only one cultural item may significantly impact any one of these states. And therefore, I think there is a need for these states to consider ratification and why that ratification has not occurred. It's more likely, of course, that ratification hasn't occurred because of constraints. And those constraints are human constraints and financial constraints, but possibly also informational and educational constraints. And that is where I think this particular volume can make a contribution in our area, Oceania. It is a valuable informational and educational tool, a tool that is probably needed by our island neighbors to understand these conventions, to understand how they work, and to assist those nations in considering whether these conventions may be of assistance to them. And I certainly endorse and hope that all those involved in the production of this volume, include the publishers, do what they need to do to make sure that this is available to our small island developing states in our region to assist them in becoming party to these conventions. Thank you.
Thank you so much, Craig. That's, as always, not just informative, but also the advocacy that's so important in our region around ratification, but also the hindrances to that ratification and how we can do what we can do to help overcome those obstacles. And because of the objectives of these treaties, which were pushed by many countries which are in similar position to our neighbouring states. So now I'd like to welcome Professor Chris Wilson. Professor Wilson is an associate professor at the College of Business, Government and Law at Flinders University in Adelaide. His work covers Indigenous traditional knowledge in a digital context and Indigenous legal relations and cultural and intellectual property protection. He is a member of the UNIDROIT Working Group on Private Collections of Orphan Objects and a member of the editorial board of the International Journal of Cultural Property, published by Cambridge University Press. He is presently co-editing a 2-volume special issue on decolonising cultural property for that journal. Professor Wilson holds a DPhil from the University of Oxford. We are privileged to have him as a collaborator on the UNESCO chair. Professor Wilson, thank you for accepting this invitation and welcome.
Thank you, Anna, and thanks to everyone gathered here to celebrate this collection. I'm speaking to you from Gadigal country, like Anna, but I bring with me my perspective as a critically minded legal scholar who's also the descendant of the Arabana and Diri peoples from Kaditunda Lake Eyre in central South Australia. So it's a privilege to be able to contribute to these discussions and to reflect on the issues explored in my chapter in the collection, which was on Indigenous restitution claims. So my focus in the chapter and in my remarks today is on how international cultural property law has struggled and is still struggling to respond to that unique and distinct position of Indigenous peoples and our cultural property, while reflecting on some of the important steps that were taken in UNIDROIT 95 Convention and some of the successes that have emerged since. So I'll touch on the broad framework established in the 95 Convention, how it tried to make space or tries to make space for Indigenous voices in restitution claims. And then I want to look forward to what the next stage might look like as we align these mechanisms more closely with the principles of the United Nations Declarations of the Rights of Indigenous People, or UNDRIP. So when the 95 Convention was negotiated in the 1990s, focused largely on protecting the interests of states and public collections. It was only late in the drafting process, thanks to interventions from countries, particularly Australia and Canada, that Indigenous communities were mentioned and brought in. This resulted in the inclusion of Articles 3.8, 5.3d, and 7.2. And this marked a shift. So for the first time, we saw explicit recognition of Indigenous cultural property as something distinct and worthy of protection in its own right, and a recognition of some of the unique circumstances that affect property and heritage of that nature. So it's an important step in the recognition of Indigenous peoples and their rights, and it did so by creating exceptions and time limitations. But that recognition came with caveats. So Indigenous communities can only act within the framework of state parties. They're still dependent on states to bring or support their claims, often the same states whose long colonial histories are what facilitated the dispossession in the first place. And as Craig set out earlier, because the convention is not retroactive, the vast majority of cultural property taken during the colonial period remains out of reach. And as Craig also mentioned, the lack of signatories for our region is also problematic. So while the 95 Convention provided language that acknowledges Indigenous cultural interests, in practice, this hasn't necessarily translated into any kind of transformative framing, as even when Indigenous communities do have standing to bring claims, they continue to face some formidable procedural hurdles. So for example, many of us will be aware proving ownership of an item that belongs communally to a people rather than to an individual is incredibly difficult within many property law frameworks, particularly those frameworks of former colonial powers. And this is a task beyond even the complexities of establishing provenance in the first place. So a striking example is the case of the Hopi tribe and Nari-Mene in France, where the Hopi, a Native American tribe, sought to prevent the sale of sacred Katsunim masks, so ceremonial masks. The French court refused to intervene because under French law, only an owner of an item would have standing to bring a claim, and the Hopi, whose concept of ownership was communal, didn't meet that definition. The result was the masks were sold for over 1.4 million euros. So cases like this show us how Indigenous claims are often assessed through legal categorization that doesn't really recognize collective identity or spiritual belonging. So the result is that Indigenous law and worldviews can remain marginalized, even within mechanisms that have created space within them. So another key issue I explore is that the notion of cultural property, by its framing, treats matters as simple objects, items to be preserved, catalogued, traded, rather than necessarily as the embodiment of the living expressions of people and place. So for many Indigenous communities, cultural objects aren't artifacts, but relations, living participants in ceremony, knowledge transmission, cultural continuity. So steps have been taken to recognize that difference, but this difference in worldview fundamentally alters what restitution should or could mean. It's not just about recovering property for Indigenous communities, it's about restoring relationship, responsibility, and dignity. And this is where the 95 Convention framework struggles. It's designed fundamentally to protect objects, not communities, and only implicitly recognizing those broader cultural meanings. So this is where the UN Declaration of the Rights of Indigenous People, adopted in 2007, offers a more dynamic and human-centered model and a framing for us to think about where we take our approaches here going forward. So where the 95 Convention focuses on objects within private law, UNDRIP focuses on peoples, their right to self-determination, to maintain and protect their heritage. And a key consideration is the provision of free, prior, and informed consent to any process that affects them. So Articles 11 and 12 of UNDRIP recognize the right of Indigenous people to the repatriation of ceremonial objects and ancestral remains. And while the declaration is not legally binding, it's increasingly reflective of evolving customary international law, but it lacks enforcement mechanisms and procedures like the ones that are in the 95 Convention. But if we take UNDRIP seriously, it asks us to move from a system of state permission to one of Indigenous participation and consent. It asks that museums, governments, collectors shift from ownership to relationship, from acting as custodians of the past to being collaborators in cultural renewal into the future. So how do we move from aspiration to action? I suggest 3 areas of current and ongoing work. So the first is embedding free, prior, and informed consent into domestic law, into museum policies, into collecting institute policies, not as procedural checkboxes, but as a substantive right that recognizes Indigenous people as equal decision makers in the stewardship and return of cultural heritage and property. This is also important at the international law level, where meaningful engagement with Indigenous viewpoints is vital for future developments in this area, be it through direct consultation or via mechanisms such as the Permanent Forum on Indigenous Issues. Second, continuing the work that is ongoing and is proving successful in developing some hybrid legal mechanisms that bridge the gap between international instruments and human rights frameworks. So these include community to institution agreements that explicitly apply UNDRIP principles to restitution processes. We're seeing positive examples of this with the return of cultural objects to Aboriginal communities in Australia. So including in 2024, we saw 10 items from the Horniman Museum and Gardens in the UK to the Warramungu community in Tennant Creek, 20 objects from the Fowler Museum, the University of California in the US. And then after 20 years of strong advocacy and relationship building, the La Perouse community last year here in Sydney saw the return from the University of Cambridge of the 4 surviving Guigal spears. So those spears were those first taken by James Cook and Joseph Banks on April 29th, 1770. So a key moment of history and heritage, not just for La Perouse, but for Australia as well. And third, moving for deeper recognition of community ownership as a legitimate legal category. International law instruments need to be interpreted and evolved to accommodate Indigenous concepts of property, collective, spiritual, intergenerational, as set out and provided for in UNDRIP. So as Greg mentioned, these conventions and the 95 Convention were products of their time, and was an important step in recognizing Indigenous cultural heritage is not simply another category of artifacts, but is a core part of identity and sovereignty. Yet its limitations remind us that justice and restitution of cultural property depend on continuing dialogue between states and communities and institutions and collectors, between legal systems and Indigenous law, between the past and the future. So if the 95 Convention gave us the first steps of a language for Indigenous restitution, then UNDRIP gives us the vision of restitution as relationship, as recognition and repair. And that's the challenge that continues to lay before us now. Thanks.
Thank you so much, Chris. And I'm sure that your intervention will engender many or encourage many questions in our discussion, including from myself. But we now need to hear from our final panelist, Professor Ari Freshan. He is a professor at the International Studies Department of the Faculty of Law at the University of Indonesia since 2008, where he is currently chair of the Centre for Sustainable Ocean Policy. He is currently Director of Public Relations, Media, Government and International Affairs at the University of Indonesia. If that wasn't enough, he's also the chair of the Indonesian Society of International Law Lecturers from 2020 to 2025, Editor-in-Chief of the Indonesian Journal of International Law, and also Editor-in-Chief of the Indonesian Yearbook of International Law. He is a member of the Executive Board of the Asian Society of International Law. Ari has long demonstrated a commitment to the legal protection of cultural heritage in our region, including organising and hosting an international conference on this theme under the auspices of the Indonesian Society of International Law. Welcome, Ari.
Thank you, Anna, for your generous introduction. But if I may, I just last week resigned from the Director for Public Relations of the university. It is a very tough job, so I have to realize that I'm not up to it. So thank you very much. And yes, ladies and gentlemen, today I'm going to share of my contribution to the commentary books. If Professor Forrest said that his contribution was modest, well, I don't know if my contribution is called modest or not. It's a very small contribution. But however, I'm really privileged to be part of the authors of this commentary. And thanks so much, Anna, for inviting me. As we know that I'm coming from Indonesia, and Indonesia is not yet ratifying both conventions, both in Convention of 1970 and also 1995. But however, Indonesia also experienced a number of things that are quite relevant to what we are talking right now. Myself is focusing on the part of education and publication, in which this is very important for us as a society enable to contribute to the so-called cooperation of for stolen and illegally transport cultural property. As we know, Indonesia have at least two big events where back in 2013, where we have 4 ancient gold so-called very valuable cultural property was stolen in our own national museum, and up until now it's not yet being recovered. And we believe that these artifacts were sold in the black market. At the same time, we also in the last few years that Indonesia received through the bilateral diplomatic channel that a number of artifacts or cultural property being returned to Indonesia. This is a very good development, but within the legal sphere itself, it would be better if Indonesia have ratified the 2 conventions. So Indonesia may have more possibility and more avenues to return those stolen or illicit traffic of the property. So these things sometimes people, especially Indonesia, doesn't really know or maybe really care about it. So that's why the education and the publicity is very important, because we know that at least according to my readings that we have so many challenges in terms of the enforcement, or at least in the way that we treat it or we know about this so-called illicit traffic of this cultural property. Sometimes these so-called collection or collectors being around us, and they are willing to pay so much money, and also in economic terms that everybody would like to have that kind of fortune if they can have or they can send this artifact overseas, especially outside Indonesia. As for the education and awareness, and this is very important for integrate this heritage education schools in the early this education, and also the higher education in the universities. The relations between people and museums is quite different if we pay attention to what's happening, for example, in a number of countries. Museums, at least here in Indonesia and maybe also in another country in Asia, they're so quiet. There's not many people are actually coming to the museum and appreciating what's in the museum. So that's why this kind of education and also engagement to the community is very important to raise the awareness and also the belongings of this property. Not to mention the training for the enforcement officials is very important because of the turning the exit point or the entry point that they need to be aware of, and especially when there's a prosecution or legal proceedings, the judges also need to be aware of these kind of things. Yeah. And as for those who might admire the cultural property, for example, coming from Indonesia, then they will be able to know with the regional campaign that's conducted by the UNESCO through the YouTube that heritage is identity. Yeah, and you can see on the YouTube. And if we know that there's some object that's being lost, and also important to publish and to let the world know, and there's also some effort coming from the international organization about this so-called the red list. It's very important to share awareness in terms of the global sphere, so that more and more state-to-state cooperation, despite that we are not at the same forum of cooperation, but through bilateral communication and diplomatic channels, it can be done for the benefits of both states. Yeah. And this is what I mentioned, something that is really appreciative in terms of gaining awareness, education, and knowledge by the so-called the way of this current generation, where they like to have a very short video, but it's really content wise information, and this is can be used by the schools, by the universities, or even by the general public, especially the government, to say put in a very public spaces. Yeah. And ASEAN itself have made a number of declarations on this heritage protection, knowing that many parts in Southeast Asia is very rich in terms of the cultural property and very prone and vulnerable for this kind of illicit trade of the cultural property. So for my final notes, I guess both parts of the education and the publicity should become hand in hand, so that the community would gain the knowledge, the awareness, and also the belongings, the ownership of the heritage, so that if something is lost, something is stolen or taken away outside our jurisdiction, then everybody would feel the same and have the efforts how to retrieve this kind of artifacts. With the efforts of we call it as netizen, the citizen of the net, they are really able to locate through social media and so on and so forth, so they can have information to the government where this property located, and then the government will follow up with these diplomatic or bilateral channels. And of course, the state must bridge policy and public participation by way of engagement, yeah, because we know that the government have the program where the community have this so-called willingness to taking care of the property, and also again sharing the knowledge. If we know that a government in Indonesia is serious enough, or other governments is serious enough to retrieve and return the stolen property, I guess this is not impossible for the community to engage and to have information will be available things for the government in any states to recover the property. And lastly, well, I just to say that Southeast Asia experience proves that regional solidarity amplifies the impact. It means that within the ASEAN itself, at least we have the similar place to fight for our own cultural property to return, to recover, so that we will have a whole awareness and the whole thing that we should get from this cooperation from state to state. I guess that's all, Anna. Thank you very much. Looking forward for discussion.
Thank you so much, Professor Afriyanshan, for your intervention. I'm really grateful. And now I'll be able to open the floor to questions from participants, which I'll be gathering now as we begin our discussion. Now, if anybody has any questions, particularly about amongst the participants, please pop it in the Q&A. I will start off because people are often shy about these things. And I just am reminded that each of our participants, our panelists, have actually in their contributions to the volume have touched upon things that are very vital to our region in particular, although they're vital to other regions, but especially in our region, this idea about the temporal application and particularly non-retroactivity that Craig raised is particularly important. in relation, and they're topics that haven't been raised in the other regional regional launches of the volume, which is really, really interesting. The point or the intervention of Chris focusing on the rights of Indigenous peoples and how restitution can be addressed and the limitations of these two treaties, because they are very much state-based and revolves around the obligations of states. But also, the 1995 also involves non-state actors, and we can talk about that. And also Ari's intervention around raising public awareness and also education, and given the limited ratification rate in our region, which is particularly acute, given the extent of cultural loss, both past and ongoing, which is really something that needs to be addressed. So I'll throw my first question to you, Craig. Given that there are very many shy people that are amongst the participants, is if we're looking at the temporal idea, and what you said was absolutely correct, and unsurprisingly, is that the key driver for those that were pushing for particularly in the 1970 convention, was to address not just illicit traffic in the present, but also past losses. And that was something that was not likely to succeed, given the market states, as they're called, whether they were going to take that up. So, but we know that now there has been a number of key market states that have ratified the 1970 convention, and also the issue of past loss of cultural property has come to the fore, and the restitution in relation to historic claims has come to the fore. How does that marry with the work of the 1970 convention and the 1995 convention? Do they continue to be relevant even in relation to defining discussions around historic claims?
I think they're absolutely relevant. I mean, if you think of the evolution of those conventions, 1970 and 1995, I mean, what they do reflect is an evolving ethical attitude towards that cultural heritage. And for purely legal reasons, the non-retroactivity, that temporal scope of the conventions, necessitated that as a matter of law, they applied only from those point onwards. But they did reflect a changing attitude towards that cultural heritage from that point onwards. I think that changing attitude continues, so that what we have learned from the implementation of those conventions has changed the way we view the movement of cultural heritage over time, including that which occurred before the 1970 convention. So I think if you look at the way in which museums and other institutions are responding to requests for return that are not governed by those two conventions, those two conventions still form the background against which those negotiations take place and reflect the way in which we view it from this point in time, not in 1970 when they were negotiated, or 1995, or 1910 when something might have been viewed. It's the way we view it now, and the way in which we then negotiate those returns, etc. now. And I think there's, I mean, even the 1970-1995 convention, there's less recourse to those in a purely legal sense in terms of litigation, etc., than there is simply a moral recognition that they capture basic principles that ought to apply and be recognized irrespective of what had actually occurred in the past. So I think the temporal scope is purely a legal, technical scope of those conventions, but the conventions are much more than those two things. And I might touch on something else, if I may, to fill up some time.
Please
I guess you have a lot of questions. You know, one of the values of the convention is also the fact that at the end of the value of the edited volume is that you have a number of authors considering how these two conventions relate to the other UNESCO conventions. And they're all interconnected. If you look at the illicit trafficking and cultural heritage, it first appears in the 1954 convention on protecting cultural heritage and armed conflict. There's an aspect of it in the Underwater Cultural Heritage Convention. Even the Intangible Cultural Heritage Convention recognizes that objects that can be used in the intangible form part of the intangible cultural heritage. And those might also be illegally exported and may not necessarily intrinsically have the value. They simply contribute to the intangible, but they're all part of a interconnectedness between those 5 conventions. So when we're talking about ratification of these conventions in Oceania, I think it's important that we recognize that it's best not to cherry pick those conventions which are immediately of use to you, like the Intangible Cultural Heritage Convention or World Heritage Convention is for Oceania, but look at the interconnectivity of all those conventions. And I think this volume makes a really good contribution to understanding not just that interconnectivity, but the intertemporal interconnectivity of all movements of cultural heritage, whether it's war or prior to 1970 or whatever it is. So absolutely, I think they have value beyond merely the technical application. Sorry for the long answer.
No, it's actually, you made it a really wonderful segue to my question to Chris and the point that Chris made in relation to, and it was something that was raised in the Asian launch, I think it was by Professor Cornell, is a plea to go beyond the siloing by the various conventions of heritage or culture and its manifestations, is that it is very artificial. We know that it is just because of the historical way that these treaties have evolved. But it is artificial, and I think that that's something that, as Chris pointed out in his intervention, is something that is completely alien to First Nations peoples, to Indigenous peoples, and I suspect to many people, or the ordinary person on the street would probably have the same idea that that it is quite artificial, as you mentioned, that they are all interconnected. So, Chris, that is my segue to ask you the question that I was going to ask you, which is, your intervention makes a really important point, and it builds on what Craig has just mentioned, of how these two conventions are placed within the context of broader other multilateral instruments, not just the cultural conventions of UNESCO, but also international law broadly. And you mentioned the UN Declaration of the Rights of Indigenous Peoples. One of the things that has really come to the fore is how the implementation of the obligations under that declaration are placed on UNIDROIT and also UNESCO, which oversee the implementation of these two conventions. If you could offer some words by way of which they could meet those challenges today, that is the participation of Indigenous peoples in decision making, which on things that directly affect them, on these conventions themselves, but also other instruments that these two bodies oversee.
Well, so I'll just take one step back, and because I think it's really useful the way Craig just framed these conventions kind of being the framing and almost the language even in non-member states, because that's how I see UNDRIP having its most influence. It's taking that conception of what Indigenous was understood at the time of these conventions, which has evolved at the international level, and giving us the ability to broaden that discussion. Lots of communities will talk about that as having a seat at the table. We've seen the creation of the Permanent Forum on Indigenous issues, which is a useful vehicle to provide advice. The complexity of having Indigenous voices at the table in treaty negotiations is something I'm not sure there is an answer to. I think it largely is going to depend on the structure of a member state and their relationship with their Indigenous community. We see, for instance, in Australia, Victoria implementing a treaty with First Nations people there, setting up a representative body. There is scope that those kind of bodies can have input, but that, of course, is still framing it as input on, Australia in how it negotiates rather than feeding directly into the process. I think it presents a fundamental challenge, because it's also difficult on how you identify who should be speaking for a community, and the breadth and complexity of these communities all around the world it's very difficult.
But it's a difficulty that's also present for states, right? So it's not just it's all communities, including states, who represents those people, and we know we have ways of organizing that. So I don't think it's insurmountable, if that makes sense. Yeah. One would hope that all states recognize the diversity of their populations, but we know that they don't. So there's a couple of questions coming in. So I'll start with Professor Vunidilio, and I was very fortunate to be involved with a conference with Teresa recently. So she's originally from Fiji, now in California. I'll read out the question to you, which is an important one. She congratulates, thanks Australia and New Zealand for being signatories to the 1970 and New Zealand to the 1995. How can they assist Pacific Island countries, because this is something very dear to her heart, to ratify these important conventions? I will throw this because I know that Craig, and sorry, I'll give you a chance to speak, Ari, shortly, because I know Craig's been
Yes.
involved with this from the underwater heritage point of view. Whether there are some lessons learned from that work that you've done in the Pacific for assisting in the ratification of the 1995 and 1970 conventions, Craig.
I mean, as I said in my intervention, one of the things where this edited book can do is help to fill that information and educational gap. And I mean, I think that's what Australia and New Zealand can do, is simply help to educate, to understand the conventions, etc. And again, I know you've done some of this for island countries or some of our neighbors. I've done this. A lot of us have done this. And it's just an educational function, particularly in the context of usually the legislation for those individual states. So I've worked with Fiji, Solomons, Marshalls, etc. But there's only so much you can do. I mean, it's for those states to take that information and use it as information as that state sees fit. It's not for us to dictate to those states whether they need this, etc. And we can assist. And I think that assistance is there, either through UNESCO or through Australia, or many of us simply are able to assist, if we just ask this information. But ultimately, and I've experienced this before, ultimately, it comes to a point where that state has to take that process and go forward with it. And there's nothing anyone else can do other than that state. So while we can assist with education, etc., the impetus, the political pressure has to be national, domestic political pressure on the state parties to further that cause. And that pressure has to be sustained pressure. I mean, one of the things I've experienced, of course, is that there's a great deal of enthusiasm while you're there, educating, informing, working with the relevant state. But as soon as you leave, unless there's something that happens, and a disaster is the greatest impetus for ratification. But without that, sometimes that momentum is lost. And there's only so much Australia and New Zealand can do in maintaining that momentum. But again, you will have some experience with that as well, I guess.
It's interesting. My experience has been with the World Heritage Convention ratification of that, and having looked at the domestic legislation of our island neighbours, it's quite extraordinary. I would say that it's much more progressed, given that it's mapping across what their needs are. It's much more innovative than what I would anticipate, and I think people would be quite shocked in Australia. And it actually is a nice way of going into the next question of communal property ownership, is that Pacific Island countries, this is not a hard ask for them. This is something that they completely understand, whereas ours is still within that very traditional ways of understanding. When I say traditional, it's common law ways of understanding property law. Yeah. So the question that I'd like to put, it's to you, Chris, but I think that Ari, I'm happy for you to also answer it, because it does, although it doesn't cover public awareness raising, it may well elicit an answer in relation to Indonesian law and practice. So the question was from Mohammed Rafanio, and he asks, considering that cultural property regimes rely on the concept of individual ownership over property, can Indigenous peoples assert their right over their cultural property, considering their reliance on communal ownership of property? Is there any emerging practice within international law which indicates a shift towards recognition of communal ownership of property by Indigenous peoples under international law? I'll give you the floor first, Chris, and then I'll ask Ari if there's anything within Indonesian practice in this area that might be able to inform that. Chris.
Yeah, so we are seeing more and more success post UNDRIP. UNDRIP is really that normative pivot. While I know we harp on, well, I harp on and other scholars harp on that it's not binding, it is a framework that Indigenous communities are able to point to on the ground. It provides them that toolbox when they're going and approaching museums and institutions and collecting institutions. It gives them that that ability to express their claims, to frame them in a way that's understandable and push forward with progress, particularly on, as I mentioned, some of the recent successes in Australia in getting artifacts returned back. A lot of the challenges around the repatriation of objects from particularly collecting institutions, concerns around whether or not the community can look after those objects. If we put aside the offensiveness of that, considering it's their object for 1 second, what we're also seeing is UNDRIP being that framework to get support for funding to build community-based museums, archives, galleries, that become receptacles for these items to be returned to. So it's creating that linguistic, that normative framework that on the ground helps funding, building up tools, resources, and capacity, while then also framing the ability to negotiate.
Thank you very much, Chris. Ari?
Yeah, I think as Chris has mentioned about the international practice, I would like just to mentioning about Indonesia that we already have our own national law to protect the cultural property, and as Indonesia consists of a number of we call it as a local tribe culture, so we ourselves have to preserve in along with the protection coming from the government, and special reference coming from protection of environment that recognized the Society of Customary Law Society for the protection of the ownership as a communal. Let's, for example, the forest. Now the forest that is owned by the certain tribe or certain customary society. So it is very protected against the national land law, for example. So I guess this is something that the ownership of the so-called community based on the cultural property in Indonesia, at least now is having a better protection. Thank you.
Thank you very much, Ari. And before I close, I should emphasize that I think I need to do this because of work that I've done previously, and I was fortunate to do the work on the International Law Associations Committee for the customary international law nature of the UN Declaration of the Rights of Indigenous Peoples, that I need to, as a public international lawyer, emphasize that even though it's a soft law instrument as a declaration, there are large parts of that, and that report of the ILA committee is available. And that was nearly a decade ago, so I suspect there's even more state practice and opinio juris around a lot of the provisions under the UN Declaration, which indicate that it is that they are part of customary international law, significant parts of the declarations, so therefore binding on all states. So I would say, Chris, that they are binding on states, although countries, including our own, continue to say that it's a soft law instrument, and therefore the inference being that it's not binding. There are, as I said, significant parts of the UN Declaration on the Rights of Indigenous People that are recognised as part of customary international law. And we know that other countries have even legislated it into their domestic legislation, such as Canada. Okay, so let me now thank all three panellists, Professor Forrest, Wilson and Afriyachan, for their timely and broad-ranging discussion of our theme today on the multilateral regulation of the trade in cultural objects in the Oceanic region. It is especially timely as the international community commences its updating of the Sustainable Development Goals. The focus is again on effectively addressing the illicit trade in cultural goods, made more difficult with the escalating international and civil conflicts around the world, as well as climatic change. The urgency of these issues has been made clear in the outcome document of the World Conference on Cultural Policies, Mondiacult, adopted in Barcelona in early October, which reaffirmed the need to sustain the fight against illicit trafficking in cultural property through integrated and adequate policies and financing while fostering cooperation. We are grateful to our panellists for their precious time and invaluable insights. Participants are reminded that the link to this video will be provided to all attendees in coming days, when you will also be able to access and read the introduction to the commentary for free, and a discount code for those who would like to purchase it. And I recall what Craig said about trying to encourage the publisher to make it even more available to those within our region. So thank you to all for joining us today, and I hope to see you in the near future. Thank you.
Thank you very much.